Good morning. Welcome to the Maryland Public Service Commission. This has been noticed as the time and place for the commission to initiate a public rulemaking session in docket RM69. Today, the Maryland Public Service Commission will be considering proposed regulations to chapters 1, 2, and 3 of the Code of Maryland Regulations under Title 20, Subtitle 79. In terms of background, on April 7th of 2020, the Commission's technical staff filed proposed regulations petitioning to establish a rulemaking for the application of regulations governing additional notice, pre-application, and application requirements for construction of certain fossil fuel generating stations. The purpose of the proposed regulations is to align the Commission's Certificate of Public Convenience and Necessity regulations with federal requirements under the Environmental Protection Agency's Title VI to ensure that affected communities are given a meaningful opportunity to participate in the permitting process that would authorize the construction of certain fossil fuel generating stations. This petition was noticed on April 16th of 2020. Comments were due 1 month later on May 16th. Timely comments were filed in response to the petition by the state's Office of the People's Counsel, the Department of Natural Resources Power Plant Research Program, as well as the Howard Law School's Environmental Law Center in connection with Patuxent Riverkeeper. We did receive two late filed comments by the BTB Coalition that were filed on May 19th and May 18th and May 19th, both late filed. At this point, we will take appearances of the parties, and then I'll provide some instructions on how we're going to go about today's rulemaking session. We'll begin by taking appearances from the Commission's staff.
Good morning, Mr. Chairman, Commissioners. Lloyd Spivak for the Commission staff. With me is Roger Austin of the Commission Staff and Engineering Division.
Thank you. Office of People's Counsel.
Good morning, Your Honor. Patrick O'Laughlin on behalf of Office of People's Counsel.
Good morning. The Power Plant Research Program.
Good morning, Chairman and Commissioners. Steve Tolson, Assistant Attorney General, representing the Power Plant Research Program, and with me this morning is Mr. Frederick Kelly of the Power Plant Research Program.
Thank you, Mr. Tolson. Now I'll turn to non-state parties, if you'd like to just go ahead and make an appearance for the record.
Al Weaver, right here.
Thank you, Mr. Weaver. Who do you represent?
I'm with the BTB Coalition and the ECCB.
Thank you, Mr. Weaver. Anybody else?
Rita Gray, and I'm the president of the Brandon TV Southern Region Neighborhood Coalition.
Thank you, Ms. Gray. Any other participants wishing to be recognized today?
Good morning, Mr. Chairman. Joey Chan, Commission Advisor. My camera must have frozen, so I apologize for not speaking earlier.
Okay, thank you. And I believe that's it. If there's no other parties on the record today, what we're going to do is we'll have the Commission technical staff present the proposed regulations to the Commission. The commissioners, if they have questions, will inquire of the staff, and then we'll hear from both the state parties and the representatives from the BTB Coalition. So, Mr. Spivak, I'll turn it over to you and your team to begin the presentation.
Thank you, Mr. Chairman. Good morning again, Mr. Chairman and Commissioners. We are here this morning to address a staff's request for a rulemaking. The proposed regulations are intended to improve the amount of public participation in the Commission's CPCN process for proposed fossil fuel generating stations larger than 70 megawatts. The origin of this rulemaking request lies in a complaint regarding the Commission-issued order granting a CPCN for the construction of a 990 megawatt natural gas-fired electric generating station to be located in Brandywine, Maryland. After losing a Maryland court appeal, an organization acting on behalf of the residents living in the vicinity of the proposed plant filed a Title VI complaint with the Environmental Protection Agency and the U.S. Department of Transportation. Title VI prohibits any entity receiving federal money from engaging in activities with the purpose of, or the effect of, excluding individuals from participation in, denying them the benefits of, or otherwise subjecting them to discrimination under any program or activity on the basis of race, color, or national origin. The Title VI complaint alleged that the issuance of the Mattawoman CPCN was discriminatory on the basis of race because it will adversely and disproportionately impact the community in and around Brandywine, which is predominantly African American. The U.S. Department of Transportation and the U.S. EPA, upon acceptance of the complaint, opened an investigation to determine, among other things, whether the Commission's public engagement process for the Mattawoman CPCN violated Title VI. During the federal agency's investigation, the Commission agreed to enter into an informal resolution agreement with the U.S. Department of Transportation to resolve the complaint. The agreement did not address the merits of the complaint's allegations, nor did it constitute any admission by the Commission. Instead, it outlined a series of commitments that the Commission voluntarily agreed to undertake, including, among other things, the initiation of a rulemaking aimed at providing greater opportunity for community engagement and the participation of affected communities in the Commission's CPCN process for fossil fuel generating stations greater than 70 megawatts in nameplate capacity. The draft regulations are presented for the Commission's consideration this morning are meant to satisfy this commitment. They include amendments to several existing regulations in COMAR 20.79. The proposed rules would establish a pre-application process for qualifying generating stations, CPCN notification improvements, and certain application requirements for proposed fossil fuel generating stations. The purpose of these regulations, as the Chairman noted, is to align the Commission's CPCN regulations with federal requirements under Title VI to ensure that affected communities are given a full opportunity to participate in the permitting process that would authorize the construction of a large fossil fuel generating station. Mr. Chen of the Commission's advisory staff will lead the presentation of the proposed regulations this morning. In addition, Roger Austin of the Commission staff's engineering division is here and available to answer questions regarding staff's views on the proposed regulations or any comments filed by the interested parties. As previously noted, several parties have filed comments on the proposed regulations, including OPC, PPRP, the Brandywine TB Southern Region Neighborhood Coalition, and Howard University. To the extent that these organizations are present this morning and have anything to add or need to respond to Commission questions, they may speak for themselves. With that, I'll yield the floor to Mr. Chen.
Good morning, Commissioners. Joey Chen, Commission Advisor, and as Mr. Spivak said, I'm here with staff today to co-present the proposed regulations that are before you. Yes, these proposed regulations flow out of the informal resolution agreement, the IRA, which I'll be referring to throughout this presentation, reached between the Commission and the Department of Transportation's Pipeline and Hazardous Materials Safety Administration, or PHMSA. So you'll hear me refer to PHMSA as well. Before I continue, however, I would be remiss if I did not share that as part of the Title VI investigatory process, the state agencies and the complainants participated in ADR, and as a result of that, we executed a confidential non-disclosure agreement. So I mention that because there could be certain communications that I'm not permitted to disclose in this public forum. However, the rulemaking today relates directly to post-ADR activities, namely the Commission's efforts to resolve the Title VI investigation directly with PHMSA, with input from the Environmental Protection Agency, or EPA. And those communications, I'll note, with the federal agencies are not subject to the NDA. And so I think we should be okay. I just wanted to put that out there so that you are at least aware that the NDA exists. The purpose of today's rulemaking, as Mr. Spivak said, is twofold. First, it is to satisfy the Commission's commitments under the IRA to initiate this rulemaking. And I'll note that the proposed regulations reflect the commitments in the IRA in substance. And then number two is to make the CPCN process better by enhancing certain notice and public engagement requirements. So at this time, I can and I'm happy to proceed through a walkthrough of the proposed regulations, or I could yield to other parties or pause for questions that the Commission may have.
Mr. Chen, why don't we do an overview of the regulations by chapter? You don't obviously need to read them word for word. They've been published and the commissioners have reviewed them and have a copy of them. But if you'd like to give a broad overview of what we're looking at in chapter 1, we'll do that. Then we'll take questions from the commissioners and then see if other parties have anything to add.
Certainly. The proposed regulations fall within 3 categories. The first category are entirely new provisions. The second category are cleanup revisions, and the third category are what I've termed to be housekeeping changes. The new provisions, the first category, are just that. They are the new requirements that largely go to the notification, public engagement, and or CPCN application requirements. The cleanup revisions, second category, are intended to essentially tighten up COMAR where we felt that we had the opportunity to do so. And unless otherwise specified, these cleanup revisions do not introduce any substantive changes to the existing regulation. And lastly, the housekeeping changes comprise shifts in COMAR numbering as a result of any additions or deletions elsewhere upstream in that particular COMAR chapter. So, I mean, unless the Commission feels otherwise, I don't plan on discussing the housekeeping shifting. And I just want to proceed with the actual substantive or, cleanup revisions. I have prepared a visual aid that will list the proposed changes, which I'm happy to share on my screen. And before I do that, though, Mr. Spivak mentioned that there were certain comments filed in this rulemaking. In particular, PPRP and OPC have recommended specific modifications to specific regulations, and staff does not object to their proposals, and I've incorporated those in my walkthrough. So with that, I am happy to share my screen. I won't go through, Mr. Chairman, an actual walkthrough. Like you said, I'll just give an overview of that particular chapter. So I'll proceed with chapter 1. So chapter 1, if you can see my screen, you'll see to the right column will be a description of whether or not what category it falls into, if it's either a cleanup provision or a new provision, a new term. So under under 2079, subsection 01, this is a cleanup revision. Subsection 02 refers to definitions, and I will just slowly scroll through it. You'll see there's a combination of cleanup revisions here and a few newly defined terms as they will be used in the more substantive new sections under chapters 1, 2, and 3. I will highlight for you some of the key ones. We've added a new term for a community liaison officer. We've added a new term for EJ Screen, which is EPA's tool for environmental justice screening. It's a mapping tool. There are some modifications in linear facilities that PPRP have proposed, which I don't need to go into that unless you want me to right now, or I can just continue.
Mr. Chen, can I?
Yes.
Actually, Mr. Chairman, just a clarification of how we're going to take this up. I thought we were going to do more of a page turn and I'm looking at the summary document that staff distributed. So as you're going through your document, Mr. Chen, are we supposed to be stopping you, or how are we doing this? I'm just a little confused.
Thanks, Commissioner Richard. So what we're going to do is staff is going to provide a high-level overview of each of the chapters, as Mr. Chen is doing now. When he concludes, to the extent that commissioners have any questions of his overview or particular regulation changes, we'll inquire of him. After the commissioners' questions are finished, then we will turn to parties.
Okay, very good. And for me anyway, I'm having a hard time following Mr. Chen's document, but I do have a copy of the summary that you provided, which is, have nice, large, bold, ability to follow along. So anyway, I just wanted Mr. Chen to know that it's just a little, for me anyway, difficult to see the numbers of the chapters and subsections. So anyway, please, I'm sorry. Thank you.
Oh, no, thank you. And just for the parties' understanding, the commissioners do have their own private summary of the changes, although the document that Mr. Chen is looking at is similar to the document that was filed back on April 7th. Mr. Chen, if you could continue.
Okay, certainly. Thank you, Mr. Chairman. So some of the highlighted new terms include also a qualifying generating station, and this is again under 2079-0102, which sets forth the definitions under Chapter 1. And then subsection 04, so 2079-0104 is an entirely new section that covers the pre-application requirements for a qualifying generating station. And just for purposes of our discussion going forward, a qualifying generating station is defined as a fossil fuel generating facility that is greater than or equal to 70 megawatts in nameplate capacity. So this pre-application requirement involves some specific public engagement requirements for the applicant to engage before they submit an application to a CPCN application to the commission. Part of it is to provide advance notice to PPRP of their intent to file an application, and then also to attempt to engage the affected communities in a meaningful opportunity to engage the public, the affected communities. And then also there's a provision, the new section includes the preparation of a certification statement that the applicant did in fact attempt to engage the affected communities. This section also provides the EJ screen requirement, which is a new requirement to help identify sensitive communities that might experience more of the effects or impacts of the siting should the commission proceed with that. And then the remainder of this section incorporate the EJ screen requirement, the public participation certification requirement, and various cleanups. So if there are any questions, I'm happy to go through any one of these more specifically. But to Commissioner Richard, to your to help with the visual aid, if you look at the three columns, the leftmost column actually identifies the particular specific COMAR numbering, and then
Okay, thank you, Mr. Chen. That's helpful. What we'll do at this point is see if the commissioners have any questions on Chapter 1 proposed regulations. We are aware that PPRP has filed one concern supported by OPC, but we'll begin with the commissioners. And Commissioner Richard, did you have any questions on Chapter 1?
Well, yeah, I just note that at least on the documents, sorry for the page in the documents, I was looking at again the revision summary. I just noted that in several sections it states that they are non-consensus, and I guess the first one is related to affected community definitions and expanded mileage. Mr. Chen, I mean, how did you come upon these, the mile and 3 mile, these particular areas that are deemed affected?
Those numbers and those ranges were discussed with PHMSA and with EPA specifically. And EPA essentially recommended that the 1 mile. I'm sorry, I'm thinking about something else. But no, yes, those numbers were discussed and vetted and approved with with EPA's feedback and PHMSA's as well. There is a balancing that we tried to do because we understood that based on the principle of pollution in affected communities, those that lived in the closer vicinity of a particular facility are more likely to experience the effects of the any kind of pollutants that would come out. And as you radiate outward from the facility, generally the experience of the impacts of the pollutants will decline. I think with the numbering, when we discussed the 1 and 3 mile radiuses, that was trying to balance the reason setting a reasonable range for identifying those that could be more significantly impacted with the burden that a developer would likely see in terms of having to go through the notification requirements, signage requirements, and things like that. I think that ultimately in the end, if you go beyond 3 miles, you go even further to 5 to 10, there could be some that arguably would say that 5 to 10 is not enough and you would need to go further out. So to answer your question, Commissioner Richard, when we were discussing these numbers with PHMSA and with EPA, we agreed that these numbers were a reasonable ring, set up a reasonable ring, such that it would at least capture some of the more sensitive and susceptible communities closest to the facility, and yet also measured and balanced against what we anticipate could be a burden to the developer in terms of notification requirements and their efforts to engage the public.
Okay. I mean, was in these discussions with EPA, I mean, yes, if you're in a rural area and you're 3 miles out, I mean, as you pointed out, you're concerned about health effects. Why would that be any different in a urban area? Why wouldn't 3 miles also affect people who live in an urban area at that greater distance? That's kind of left me kind of scratching my head a little bit. I mean, if it's a rural, or health impact, why wouldn't it be an urban impact as well?
Well, there could be, and the idea here is, if I remember our discussions, it's to mainly make sure that for notification purposes, that those that are closest to the facility will at least have the opportunity to be notified. The notification is probably a primary focus of the public engagement, to make sure, or it's a priority, I'm sorry, of the engagement enhancements, because you want to make sure that there's that there are folks within the affected community who will at least be notified and of a particular project going up on an application, and so then relying on then community communication to then spread the word out, to then maybe that would allow others, bring in others from beyond the 1 mile or 3 mile into the discussion as well. But no, I think you are correct that physically, from a pollutant dispersion standpoint, there really isn't a difference between how far the pollutants don't necessarily travel less further in an urban setting that they do in a rural setting. It's just what we were looking at here is to make sure that we can capture individuals within the members of the affected community so that the word can get out. And 3 miles in a rural setting is fine, but in a 1 mile setting, because folks are more densely packed and reside closer together, 1 mile, we determined that 1 mile would be sufficient to at least be able to make sure that that there are folks and members of those communities will be able to at least get the notification, and then through their networks share the news and draw in people to be able to participate.
Okay. So in an urban area, though, as not to get too far ahead, the people who are in a 2 mile or 3 mile, they're not going to see any of the signs that would otherwise be put up in the 1 mile ring. You're just suggesting they should rely on people in the 1 mile ring getting the word out.
Well, I mean, the signage will be posted closest to where the facility is. But I think in terms of the mailing and notification by mailing specifically, we, to have members of the community within that 1 mile receive the actual mailers and then be able to, through their community networks, get word out even further. I think that is what we were thinking.
Okay. All right. Well, I'll be interested to hear what the Patuxent Riverkeepers, Howard University, others have to say on this. I'm right now kind of more persuaded that if 3 miles is where the health hazard is, according to EPA, that's where people should be. Those people should be notified. So anyway, thank you.
Thank you. Any additional?
Yes, Mr. Chairman. Mr. Chen, I have a number of questions, some of which are related to just cleanup and some of which are a little bit more substantive. Can you first explain to me why you eliminated electric company from the scope? Is it because an electric company is a person, or is it because you think electric companies, this doesn't apply to them?
Commissioner, do you mind if I pull up the visual aid?
No, go ahead.
Okay. So I'm sorry, would you?
7901B. Very top.
Okay. Oh, so this okay, so this was a cleanup revision, and I think that a person adequately captures. It's not limited to an electric company, so a person would include an electric company. However, in our state, an electric company or electric utility arguably would not be. I'm sorry. Let me take a step back. And let me take a step back. This edit was to consolidate. The whole purpose of this was to consolidate, so that it would include that a person, this A would then contemplate both persons that are applying for CPCNs for generating facilities, and then also for applicants for transmission lines. So it was.
I just want to be clear, because by law, an electric company may be required or allowed to construct a generating facility. So I want to make sure that this is not intended to exclude electric companies from this regulation. I assume it doesn't. I just wanted to clarify that. So I wanted to be clear. I believe person includes electric company, but I just wanted to be clear that wasn't the intent, because I don't agree with that intent. Okay, so we're clear on that one. In O2, when you talk about the affected community with rural and urban as defined by the United States Census Bureau, I have to tell you that I went online and did about 5 or 6 different clicks trying to find the definition of where I might find definitions of urban and rural. I couldn't find it. So is there a specific document or regulation that we ought to be citing so we can understand what that means? Because, like I said, I didn't spend half an hour looking, but I don't think our regulations should require a in-depth legal search to find a definition.
No, I note that the Census Bureau defines urban as comprising all territory and population and housing units that are located in urbanized areas and in places of 2,500 or more inhabitants outside of urbanized areas. And then an urbanized area itself is a term that's defined as a continuously built up area with a population of 50,000 or more. And I found that, I also did a search too, and that I found that through the Census Bureau website. And the rural is defined as a territory, population, or housing units that are not otherwise classified as urban. So I think my understanding of structuring regulations in COMAR is that I think we would be referencing the definition through the United States Census Bureau. I'm not sure if are you suggesting, Commissioner, that we should incorporate that definition here in COMAR?
Well, because normally we might say you just say as defined by the U.S. Census Bureau without providing a citation or anything to where somebody might go to try to find the definition. The U.S. Census Bureau, to me, normally we might say as defined by the such and such act or such and such law. And like I said, I didn't spend a long time, but I did spend a few minutes. So I'm just wondering if there's any more specificity that can be brought to that so that people can find it more easily than having to go and search search for, I don't even know what the U.S. Census Bureau statute is or regulations are, where do you find them? Where are they? So that's what I'm wondering, if there's a slightly more specific site that might assist people in trying to understand what that means.
I'm not sure if it's defined by statute. I don't know.
Regulation, I'm just trying to, for example, we might say as defined by, 47 US, CFR such and such, or something like that. Or in Title 47 of the Code of Federal Regulations, at least it gives you a hint as to where to go as opposed to the Census Bureau. But I'll move on and you can think about that one. I've noticed that in a number of places throughout these regulations, I'll just note that defined terms need to be capitalized so that people know it's a defined term, so they know they need to go and look it up. I think that's important. So that's kind of all throughout. So when we publish these, we want to make sure that, I don't think that's a substantive change, but defined terms should be capitalized. Moving on to 04A. 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 In A itself, you use on the second line there, I see you say qualifying generating station no less than 90 days prior to filing the application. And then you say, and provide information on the proposed generating station. Is that the qualifying, do you need the qualifying in there or do you not necessarily need it? It is a defined term, so you may want to add qualifying there. Again, not necessarily a substantive change, but something you should look at. In B2, let's go to B2. This one is identify actual community members and community organizations. Those aren't defined terms, are they? Actual community members and community?
No,
right. That's a tough one. How do we? We're just sort of going to report. The person building the generating station is just going to say, this is how I identified them, and is there? That one's a little potentially difficult to comply with, because somebody could come up later and say, I'm an actual community member or I'm a community organization. How are they going to do that?
I believe the what we envision would happen is that the developer would through, I guess, various resources available either online, through communications with who they know and the organization they know already do exist in the affected communities in the the established area, what is would be determined, would be deemed as an affected community, would then certainly, I think they can get a list of determine who lives there, and then they can probably through an internet search determine which organizations are fall within that particular area, and then make whatever best effort attempts to list those and engage with those. I think that part of the other information that they would get is if they do hold one of these public meetings with the sign-in sheet, they could determine who's attended and find out additional or more information from what that particular individual has put down.
Okay, I'm just, that and I think BTB sort of comments kind of relate somewhat to that question. In 04D2 and 3, or at least in 3, how do how these, like, for example, in 3, it talks about 200% of the poverty level and that kind of thing. How is it that a person building a generating facility finds that information?
So they would largely be relying on the EJ Screen tool. And the EJ Screen tool, they can plug in a particular location either by entering it in a field or using a map function. And the EJ tool, they will allow them to set the location. And once the location is set, can define a particular block radius. In this case, it would be a 3-mile radius. And then from there, that information gets populated into a standard report. And then in that report, it has graphic representations and data representations of demographic information. So the EJ Screen tool already has in its mechanics the calculus for determining how many are low income in this area, how many are minority population in this area, and then it will generate it into a report.
Okay, so it's already in the screen. They don't have to go out and try to find it. It's already in the tool. Okay.
No, we
great.
would be expecting them to utilize the information that's available through EJ Screen.
Okay, and my final question relates to PPRP's definition of linear facilities, where they suggest that it shouldn't include the term overhead transmission line. And staff has said that they're okay with that. Does that raise any jurisdictional issues, since we don't have jurisdiction over the construction of underground transmission lines? That's, our statute is limited to overhead transmission lines.
I'm going to have to defer to staff on that, and I believe Mr. Austin is available, as well as PPRP. Let's see if Mr. Austin can answer that.
Yeah, I'm here. So we went with the definition of linear facilities that PPRP suggested, because that is the nationally accepted definition of linear facilities. As far as the jurisdiction of underground transmission lines, I am not sure how that would affect the wording of the statute. But as far as the definition of linear facilities, I think what PPRP suggested is accurate.
Mr. Spivak, do you have a comment on that?
I have nothing to add, Commissioner.
Do you, I mean, isn't our jurisdiction limited to overhead transmission lines?
Sorry. Yes, I mean, we do not issue CPCNs for underground transmission lines.
Right, so that's something that I'm not sure that, I don't know if Mr. Tolson wants to pipe, come in this discussion, but that was my concern. I'm not saying that, I'm just trying to make sure we don't run up afoul of a jurisdictional issue since we don't issue CPCNs for underground transmission lines.
Commissioner Herman and Steve Tolson, Fred Kelly is on the line, and I believe that Mr. Kelly's concern from PPRP was with interconnection portions where there might be a part that is underground, but it is also integral to the overall facility. And if he's here, I'm going to stand back and ask for him to address that because my letter says, I was presenting his views on it.
Good morning. This is Fred Kelly. We included that in there in that when we're looking at a generating station, we're looking at all the linear facilities that are associated with it, including maybe a natural gas pipeline, reclaimed water pipeline. Those are all underground facilities. If the interconnection or whatever cable interconnects the project is underground overhead, it may have environmental impacts associated with that. We just want to have a comprehensive view of a project so that there isn't anything that is not understood. We don't want to have a stranded asset out there if the interconnection has something that might bog it down somewhere. So, and then oftentimes, I think, especially on solar projects, the interconnection cable is not even at the 69 kV level. They can interconnect at distribution levels as well. So I guess from PPRP's point of view is we just want to have a comprehensive review of the whole project. And we think that the interconnecting cable is counted as a linear facility, and the environmental impacts associated with that should be understood in the CPCN review.
Okay, thank you. Thank you, Mr. Chairman. That's all I had.
Thank you, Commissioner Herman. Commissioner O'Donnell.
Mr. Chen, thank you, Mr. Chairman. Mr. Chen, could you go to subparagraph 09 real quick so I can take a look?
Certainly. Just a moment. I'm sorry, Commissioner, can you say that one more time?
09 was the last provision that you had on your original presentation.
09 here, the completeness determination.
Yes, this is a different document now, right?
It is because I think this one with the coloring scheme might be better visually.
Yeah, so I saw something before that I'm not seeing now, which was a red.
Okay, if you want me to, I can pull up this. You saw a red, and I apologize for the fast scrolling.
And just to be clear, the document that we just saw on the screen was the actual proposed regulations of April 7th. This other document, which is a little smaller and hard to read, it's an unofficial staff guide.
Commissioner O'Donnell, is this the 09 section you were referring to?
I can't see anything. It just says viewing J. Chen's applications, but I don't, it's just a blank screen.
Okay, I apologize. Let me try to do this again. Okay, let me try to do this again. Can you see the document now?
Yes.
Okay. And 28, is this the 09 provision?
Yes, okay. It was a strikeout that I couldn't quite focus on when we went through it the first time, the word state, and I didn't know what was going on there, and I wanted to come back to it. Okay, I'm satisfied.
Okay. Mr. Chairman, if it's okay, I'd like to use the as filed document with the colors.
That would be more helpful, Mr. Chen, if we could dispatch with the current sheet that you have and just use the as filed proposal.
Okay.
Thank you. Okay, so any additional questions from commissioners? We've.
Yes, Mr. Chairman. Can you hear me?
Mr. Linton, go ahead. Thanks.
Sure. Thank you. Mr. Chen, I'm actually using the April 7th filing, so switching to that one works fine for me. I take you back to section 02 under the definitions portion, or 02B.
Yes.
Number 13. I'm specifically focusing on the EJ screen definition.
Is this what you see here?
Yes, that's it.
Okay.
At the bottom of page 3. So I had a chance to look at the EJ screen. I understand it was first released to the public in 2015. We are effectively relying on it for a lot of the operational elements of this regulation when we direct the applicant to use it for different reasons throughout this regulation. So my question is, if for some reason this tool is not available or is limited in some way, even the tool itself says that it has to be used in conjunction with other information, some information that's available in the location that's being reviewed at the time, or information that you have just from being in that region. If this tool is not available, how is the applicant supposed to move forward with the other responsibilities and the regulation?
Well, the right now the obligation on the developer is, or the applicant is to conduct the EJ, run an EJ screen report, generate those, and include them with the application. And as you noted, that the EJ screen does have its limitations, and the purpose of the EJ screen is not to be the end all be all as far as disparate impact, potential raising those type of potential disparate impact issues. What the tool is designed to do is to serve as a starting point, a pre-decisional mechanism or means by which the commission or the public utility law judge, if so delegated, could use to identify whether or not there could be a sensitive area that might experience more of an impact or raise some kind of impact concern. So that would then open the door for discussion. And then the decision maker could then decide how best to proceed. Now, if for some reason the EJ screen tool is unavailable, then that would, I think still, that is something that the applicant would assume disclose in their indicate in their application as to why their application does not include an EJ screen report, and then on a case-by-case basis, the decision maker would then decide how best to proceed. That could be, going back to the developer at the appropriate juncture, let's say at the pre-hearing conference, And this is just, I'm just stating a hypothetical here.
Well, I guess along those lines, if you move to the bottom of page 7, you'll get an example of what I'm referencing.
Okay.
And this is for everybody tuning in. This is section D in section 4, but it's right at the bottom of page 7. Now you'll see there that there's a directive to the applicant, and we're using the word shall here. Use the EJ screen to conduct the different responsibilities that are noted here. So, and the way the regulation is written now, use of the EJ screen, other responsibilities build from reliance on the tool. And the tool is not, as I was noting earlier, it's not something that the commission monitors and establishes. It's not something that the applicant monitors and establishes. And so I'm certain that the EPA has every interest in moving forward with continuing to maintain it. But, you know, if the last couple of months haven't taught us anything, is that things change. So I'm just curious about maybe the solution, I think, would be to add some language in here so that, this is my hand in front of the screen, so that if for some reason this tool is not available, the applicant is not excused from still going forward with this work. So there's some language on the EPA's website that talks about how this is the proper uses for the EJ screen tool and what other types of what it's meant to do, what it's not meant to do, what it's meant to be used for, what it's not meant to be used for. And so maybe there's a couple of phrases we can borrow from there to incorporate into this section so that the applicant's not excused from going forward with this work if for some reason the EJ screen is not available. In other words, we don't want this just to become a component where in the future, again, using a hypothetical, an applicant can just have a standard paragraph that says the EJ screen is not available, so we didn't have to comply with section D. So that was my concern.
Okay, that's noted, Commissioner. I think in terms of workshopping additional language, I think, you know, I would certainly be open to that. But I wouldn't.
Yeah, and in terms of wording, I mean, if maybe after a break or something, I could come back with a couple of phrases. I don't think we need a lot. And because we're using the word shall in there, it's just a matter of adding a phrase that offers, that maintains the responsibility even if the tool is not available. I mean, the website could just be down, for example, for a period of time, so that you just never know. So I want to make sure that if we're going to give the applicant a responsibility, that they're required to complete it, even if the tool they're supposed to use isn't available. That's all. So I'll move to a different question I had on page 6 of the same document. This is 04, well, it's 04. Sections, there's a section A and a B already. And this is a new section that talks about actions that the applicant is supposed to take prior to filing the CPCN. And we have an A and a B here regarding notification to the communities and to the DNR PPRP. What I wanted to recommend is that we incorporate a high level notification to the Commission's Consumer Affairs Division for the sole purpose of allowing them to be able to direct customers to the applicant's other resources, their website or whatever else is necessary, so that we as a commission is not in the position of not knowing that this interaction is happening with the public and the applicant. So customers will call us, and so it's useful for us to be able to say, hasn't been filed yet, you need to go to this website or this location for more information. So I don't know if it has to be adding a C after A and B, or if it could just be incorporated into A. But either one I think would work.
So we could, if it's agreeable to you, Commissioner, we could amend A to insert, notify the commission, or the
And I think,
commission, or the commission's non-discrimination coordinator, and the Maryland Department of Natural Resources Power Plant Research Program. So we would be, or the commission, I'm sorry, would be receiving the same information that PPRP would be receiving in advance, if that makes
right.
sense.
I think that's fine. It's just to make sure that that we know, so we can direct any consumers to the appropriate place if they call us first. I had one more, and it is on page 7. See, this is it's a little 4I, little Roman numeral 4.
Okay, I'm here.
So this is providing a copy of the meeting invitation or newspaper advertisement to the governing body and the executive. So I'm assuming that there's something. Is this? Well, let me just ask: is this just considered a high level notification so that the executive knows that something is happening, or are we expecting the governing body to take additional action as a result of receiving the notice?
I believe at minimum, it is really just to provide the governing body with notification. So in case they get calls from their constituents, they can at least, be in the same position as your previous suggestion, saying, okay, this is what we're aware of is going on. And if the governing body is also receiving, let me just scroll up slightly, information about a public meeting, then the governing body can direct the caller to and provide that caller with information as well. Because in a scenario, there could be interested persons. I'll just say that interested persons that fall well outside of the affected community radius, be it 1 mile or 3 mile, and they take interest. They may not have received a notification themselves, right, a mailer themselves, but they know who to call, and so they call the governing body, and so they can get information that way. So it is an attempt to just provide at least information to folks who could then choose to act if they want. Because at this point, if the governing body is brought into the process early as part of public engagement, then later on, if it might inform that governing body if they should so desire to participate in the CPCN process through intervention, or file with the commission some sort of opinion or recommendation that would then come in under a due consideration analysis under 7207E. So again, this is just to keep them informed, I believe.
Okay, so when we use the term governing body, then we're referring to the county level governing body, and not necessarily incorporated towns and local municipalities, things of that sort.
No, I think it is meant to include the municipal governments. It's that's if in the language itself there, it does say the executive of the county and the municipal corporation.
Okay, so all right, that's fine. Then if we're going to do that, then I don't know if we define local governments. No, I don't think we do. Okay. So we haven't defined local government or governing body here in our regulation. Something we may want to consider doing I do know we define government. We ran into this issue before with a different set of regulations, and we ended up focusing on county governments instead because of some other because of the notice provisions that we wanted to incorporate. I don't know that those apply here, but I guess we just have to think about whether or not governing body is a phrase to use and what that actually means, because there's, depending on where this generating station or transmission line is located, there could be a lot of different entities that you cross over, small towns and that have a structure to them that could fit under the definition of governing body. And so we don't want them to come up later and say, we never received anything. The line goes right over a corner of our township, et cetera. So if we intend this to mean any incorporated town, local governing body, et cetera, that is impacted by the regulations as designed now, then we need to clarify what we mean by that so that the applicants know that they're supposed to reach out to those governing bodies as well as the overall county government.
Commissioner Linton, would your concern be addressed if we replace governing body with local governments?
That would help. I think that there are some definitions of that would cover this in the statute. I have not looked at them recently, so I'll probably pull one up, and the public, maybe of the members of the work group could do it as well. But I think that, Mr. Chairman, that would get us a little closer to the kind of concern I'm raising. I just want to make sure that we don't have a town show up later to say, we never received any of these notifications, and your regulation says governing body, and we are one.
Can I weigh in here on this? So in my opinion, local governments, that language is more nebulous, not less nebulous than the existing language. I believe a better route would be to say the governing body and applicable executive of each county or municipal corporation as defined in, and cite the definition, because I know they're defined, they're specific terms as we use elsewhere in notifications.
Yes.
And I would prefer to go that way. If you get into local governments, it's who in local government, what entity in local government. It gets messy. So I would prefer we not just go with local governments. It's too nebulous, and it becomes very messy at that point.
Well, to that point, I would note in section 3, directly above the one I was referencing, the advertisement in the newspaper of general circulation in the county or municipal corporation. So we're using the term municipal corporation in 3, and in 4 we're using governing body. So I think we just need to make sure we're using language here to reach who we would like to reach, have the applicant reach whom we'd like to reach.
And I agree with that. I think you're right, but I think my opinion is using the terminology local government takes us further away from that goal than closer to it, maybe.
So commissioners, the 7207E requires the commission to consider the recommendation, and here's the quote, of the governing body of each county or municipal corporation in which a portion of the construction of the generation station is proposed to be located. So would it be acceptable to just to make the proposed term in little 4 consistent with what we have in the statute?
I think that gives us more clarity of what it covers the regulation more, for sure. I just want to make sure that the applicant understands that terminology, what we intend that terminology to mean by incorporating it in our regulation, is that it includes the local townships. And if that's, as long as that's clear, then I think that language, pulling it from the statute would be fine. But if we intend something different, then we need to make sure that's clear for the applicant.
From the drafter standpoint, I think my goal would be and is to make it consistent with the phrases and the terms that you see elsewhere in the CPCN statute. So if it's used in the CPCN statute and how it's used in the CPCN statute, that consistency with that for me anyway would be of high priority. So if you think that the definition of governing body of each county and municipal corporation, this is we need to make a reference, as Commissioner O'Donnell suggested, then there's a way to, I think there's a way to incorporate that.
Is there any objection to using the language in 7207, the CPCN statute? Okay, hearing none, it would make sense to have these two definitions to be consistent between the regs and the statute.
Mr. Chairman, would that include section D little Roman numeral 3 as well?
Sorry, of the reg or the statute?
The regulation. Well, we reference municipal corporation in B3. Basically making sure that the language is the same for both of them. You have municipal corporation in 3 and governing body in 4.
So the that was intended to pull. Hold on. Can you hear me? Am I okay? That was intended to pull from the 7207 statute under C, 7207C, where it provides notice to interested persons. The language there is applicant provides notice immediately of the application to, and then in little 2 is the governing body, and if applicable, the executive of each county or municipal corporation in which any portion of the generating station is proposed to be constructed. So again, I would, if it's applicable, I would swap that language.
Yeah. And that's about as clear as you can get, really, in terms of saying who this has to go to within the local governments.
I think that's very important to be very specific, because you could run into a problem where an applicant notifies a planning department of a county or a municipality and they think they've met their requirement when they really haven't met the intent of the regulations, which is to notify the heads of these local governments, and that the advertising occurs in the geographic subdivision of the municipality or the corporation. And if you're not real clear on that, you get in trouble.
So, Commissioner O'Donnell, would you suggest then that for little 3 here, that that it needs a little bit more specification? And what I mean by that is inserting the word subdivision.
No, I'm not suggesting that. I'm just talking generally, not necessarily about little 3, and that you have to be careful not to go so generic that local government could mean a lot of things. That's all. I'm really reiterating my previous point, but if you can define those terms, or if they're defined and you can define them by reference, that's really what I'm suggesting.
Okay.
That's all I had, Mr. Chairman.
Thank you, Commissioner. Any additional questions from the commissioners?
Mr. Chairman, are we still on Chapter 1?
Still on Chapter 1.
Oh, okay. I was interested in subchapter 4. I think I'm on the right place now. I'm looking at the revisions document, so that's why it's different. I think this was in reference to the number of public meetings. Can I just ask, Mr. Chin, right now we're just suggesting one is sufficient. As you probably read, Howard University Patuxent Riverkeepers are requesting more, and that they be on different days and times to ensure that they accommodate the maximum number of people. Did you have a thought on that recommendation, or is why you just drafted this as one public meeting?
Well, the minimum of one is what satisfies PHMSA and EPA when we engaged in dialogue with them. It's not, the developer can certainly hold more. And if the commission feels that that it's important to require the developer to hold a minimum of 2 or 3, then that's certainly within that's your call to make. The one meeting, I think, in terms of a time frame, that's scheduling the meeting time wise within 60 days out of filing an application all fits together. But I think the one public meeting is just kind of structured pretty loosely, I think, under the current CPCN requirement for public meetings. Although I know in practice, several of our law judges try to hold at least 2. So, I mean, I don't have an adverse opinion or objection, but I just, the one is reflective of our conversations with PHMSA and DOT and what satisfies their, requirement.
Okay. And you read the Howard University Patuxent Riverkeeper. They had concerns about again, public transportation and people's ability who may work different types of jobs that have weekend shifts or evening shifts to try to accommodate that population. So, I mean, do you have any thoughts on that? Would that be disruptive to an applicant?
Would it be I think what to try to accommodate. Well, I'm sorry. Did you ask? Would it be disruptive to the applicant?
I guess I might quite mean it that way, but do you think that would be overly burdensome, or do you think that would? I think requiring maybe I don't know a number 3 meetings on different days of the week and at different times. I think both satisfy the concerns of maximum public participation and reasonable for an applicant.
I think it's probably reasonable to have an applicant schedule. If they're going to hold two, let's say 2, if they're going to hold 2 meetings, to have them held and structured at different times and at different locations in order to provide opportunity to maybe bring in different groups of folks who may or may only be able to attend one or the other. So, I mean, that's a reasonable specific instruction and directive there. I think that holding the meeting itself and providing notice, again, it's just they probably schedule in advance. They probably could provide details of both meetings in the same notification, so that wouldn't that may not increase, or the cost increases could be just marginal. However, one thing to keep in mind are the cost considerations if they do in fact have to notice on separate occasions to separate people. So you let's say issue a few hundred notices for the first meeting, you'd have to issue the same few hundred notices for the second meeting, just to make sure that you are blanketing the appropriate radius. So
just put it in a notice for public meetings and say there will be 3 public meetings, different locations, different
And have
dates.
dates and locations disclosed. I mean, they could do that. Sure, they could certainly do that. But you know, I did read and I do understand where the Tucson River Keeper Howard University laws comments are where they're coming from, and I think it's just kind of a measured balance in terms of what the cost implications could be for the developer. But you know, already as far as the CPCN process goes, once they're in the CPCN process, it's not unheard of for the commission to require or set into, you know, public comment hearings once we're actually in the CPCN view.
Okay.
So,
Mr. Chairman, I'd just like to suggest here we try to accommodate this request and require a minimum of 3 public meetings on different dates and times. Also taking into consideration accessibility to local public transportation.
Thank you, Commissioner Richard. I felt that the proposed regulations were reasonable with the one meeting with sufficient prior notice. If other commissioners have a viewpoint, now would be the time.
Yeah, I too viewed the proposed minimum of 1 public meeting doesn't preclude additional public meetings as adequate. And I think that's consistent with, for instance, what we may do with a rate case public hearing. Sometimes we have more than 1, but I don't believe we're required to. So, and I think it's consistent with how we operate with regard to engaging the public on an ongoing basis as well.
I think the wording of minimum is probably the saving grace for this section. Hopefully, an applicant will be responsive to the interest in the community and certainly hold more if they need to do so.
Yeah, I agree. I think with the minimum, and also the fact that this is a pre-filing, this is even a pre-filing meeting, so there's opportunities for public engagement that go beyond this as well. So I think this is only the first opportunity for public engagement, and if someone were to suggest that there hadn't been sufficient public engagement, they could do so at the commission itself and have more meetings, you know, have more than one commission public meeting if they felt it was insufficient the first time around.
Commissioner Richard, did you have any additional comments?
Well, I mean, obviously, I guess we'll just hope, I guess is what we have decided on this one, that we'll have enough public hearings and people will be satisfied. I think also going back to the affected public, affected community, I guess that would be a place where I would also suggest just having a uniform 3 mile for both urban and for rural. So I would like to propose that again at the suggestion of Howard University and Patuxent River Keepers.
Thank you. I too was comfortable with staff's proposal for the reasonings that Mr. Chen explained earlier, the distinction between the rural and the urban populations. So I was okay with the radiuses specified 1 mile and 3 mile.
Similarly, Mr. Chairman, I concur with that sentiment of yours. To me, this, and Commissioner Richard makes a good point that the potential physiological or health effects could go beyond these limitations, of course, no matter where you set them. But to me, this provision was more about generating a sufficient level of interest amongst the affected community so that the word is out there, and this is not flying under the radar screen. So this provision, to me, speaking for myself, is more about communication than it is about the physiological effect or that sort of effect. So it's communication provision to make sure you get a sufficient word out into the affected community.
Yeah, I also agree with, I think we've tended to find out that when citizens need to find out about something, they're pretty adept at doing so. So I don't think we'll be limited. The information will just get stuck within that 1 mile radius. So I think 1 in 3 is sufficient. I think it's something that an applicant will be able to manage fairly efficiently, and consumers will make sure that the word gets beyond that if they need to.
Yeah, I'll concur with the chairman and my other colleagues. So I'm comfortable with 1 to 3 right now.
Thank you. Commissioner Richard, additional items?
Yeah, finally, it looks like subchapter 5. I think I'm looking at the right one here. How are we defining right now significant, or yes, public engagement? Sufficient public engagement, I guess, is the issue that was raised by Howard University and Patuxent. I mean, is there you think they have a good point here in trying to define what sufficient public engagement is?
Commissioner, I'm looking at sub 5. Are you looking at letter L? Are you
5. It's 5. Yeah, let me see. Yeah, it's L. It's yeah, L. I'm sorry.
Okay. Well, so the term sufficient public engagement is a term in the commenter's comments. What we are, at least in the regs, are not looking to try to weigh in as to define what is sufficient or what is not. Only that from a neutral standpoint, the regs are designed to ensure that the developer or the applicant has made efforts to try to engage the public, and that they're required to file a statement certifying that what in fact did they do to try and do that. And whether or not that is ultimately sufficient would probably come to actually argued by the parties, if there are parties that would push back on it, and then evaluated, considered by the ultimate decision maker. So, from a standpoint of PHMSA, EPA, if you look at the guidelines for EPA's public involvement and interaction, the guidelines simply try to say that meaningful public involvement that consists of informing and consulting and working with these potentially affected communities early on in the permitting process and throughout the various stages of the process itself. But let's just focus on the early pre-decision, pre-application phase of this portion of this, because that was the focus of our discussions with PHMSA and EPA. They wanted to basically say, hey, what do you think can you do to try to engage these potentially affected communities and individuals before the CPCN process kicks off? Because we understand I'm trying to channel the federal agencies here. The federal agencies, at least, they understood that once the CPCN process triggers and once it is activated, the neutrality and the procedural process need to be maintained. The integrity of that need to be maintained. So the opportunity then is to try to engage or have the applicant facilitate the applicant engaging the public before that happens. And so I think that to the point here, a pre-application requirement and then a certification of what the applicant has done, it at least tease the issue or issue up for the commission throughout the once the application is filed and once the CPCN process has started.
Commissioner Richard,
I just, yeah, since I don't really have a metric, I looked through their comments and since we don't have a representative, at this point, I don't have anything to suggest on this one.
Commissioner
yeah,
Richard?
Yeah, I'm sorry.
Yeah, could I just ask a question in addition to what to the point you're raising?
Sure.
On page 7, item number C, which is I have to go up a little bit to find it. This is all new language. It sounds like the phrase public engagement and participation, excuse me, is a term of art. It looks like you're creating a new form for that the applicant is supposed to complete, but I don't believe we've defined that form in our definition section up top. I'm checking to make sure. I didn't see it before.
You are correct, Commissioner, and I think I went back and looked at this, and I was going to suggest, and I would at this time like to suggest my own revision here, replacing this language, which I'm highlighting, because that is a specific title, replacing this with essentially what you see, and I do apologize for the fast scrolling here. Statement of public engagement and participation certification, because this is the phrase that that is used later in chapter 3. So I think for consistency purposes, and it might resolve your logistic question, I would. Where is it here?
So
Here. I would suggest replacing this with the below phrase to make it consistent throughout the 3 regulations, the 3 chapters.
Okay, so then there's not a pre-established form that an applicant has to complete, but rather this is a certification that the applicant provides once they're prepared to file their formal CPCN application.
No, the regulations would still require the applicant to submit a signed certification statement, and what attachment C to the rulemaking documents would effectively does is provide a template, an exemplar for that the commission can then post on its website. And then the applicant can go to the commission's website and use that form, fill out that form, and include that with its application, and that, barring the information is completed to the best of their ability, would, I would think, satisfy the regulatory requirements. I'm sorry, this is
We're going to be taking a 5-minute break as soon as we wrap this up.
Right. So I think that it would still satisfy. It would certainly, filling out the form pulled down from the commission website would satisfy the requirement, and that is probably what our staff team would recommend as a best practice for any developer who asks what should they do in this instance.
Okay, so the form itself is going to elicit the information that's in section C. I guess whatever other information the commission wants on it.
Well, so when we get to it, chapter 3 has more detailed requirements as to what should be included in that statement, and what that statement needs to accomplish. And the form itself is certainly more detailed. But at this time, I mean, we are not specifically asking the commission to adopt this particular form as part of COMAR. The commission can't do that if you feel that that's what needs to be done. but we think that you could just use the form, the attachment C, as a template that you can make available publicly on the website.
Thank you, Mr. Chen. Commissioner
Mr.
Linton,
Chairman, we don't intend to bring up the form today. Is that what I understand?
yeah, we haven't reached the form yet, but we will be discussing attachment C after we get through the 3 chapters.
Okay.
Commissioner Linton, did you have a additional question or thought, or were you satisfied?
Oh, I am certainly, Mr. Chairman. No other question.
Thanks. Does Commissioner Richard, we were in the middle of your line of questioning. Do you have additional questions on chapter 1?
For L, no, I really didn't have, since again, we don't have representatives from from Howard University, Patuxent River. I would have been interested to know a metric of some kind that they may have had in mind for, getting to that, their question about sufficient public engagement. So anyway, I'm done with that line of questioning.
Well,
Sure. We'll take a 5-minute break now, and then what we'll do is we're not done with chapter 1 yet. I want to give the opportunity to any parties to speak to what we discussed in chapter 1. Then we'll move to chapter 2. So we will reconvene at 11:35. Thank you. Okay, we are back on the record. At this point, I wanted to see if there were parties that had any comments with respect to the regulations in Chapter 1. I recognize that Commissioner Herman has addressed the concern of PPRP. Perhaps we'll start with Mr. Towson if your concern was addressed.
I believe so. And if Mr. Kelly's online, if he can confirm that he's satisfied.
Yeah, this is Fred Kelly again. Yeah, I provided a bad example, I guess, when I was speaking about the interconnection of a generating station. It wouldn't with these regulations, it wouldn't apply to solar projects, but we still do strongly feel that the interconnection is an integral part of a new generating station and should be included in the CPCN review to comprehensively look at all the potential environmental impacts. So I just offer that clarification.
Thank you, Mr. Kelly. I appreciated that conversation you had with Commissioner Herman. Any last call for additional comments on Chapter 1?
Mr. Chairman, Mr. Chen, I can ask a question, one more question of Mr. Chen. With the definitions of urban and rural areas, I guess we cite the United States Census Bureau. Can you just inform me? I was trying to find those and I could not. I realized I made notes on my other document. How do those apply? I mean, how do we define these terms? I mean, I'm thinking like in Southern Maryland, for instance, you've got an area where you may have Waldorf, but quickly it becomes a very rural area outside of Waldorf, Maryland. What do you do in those types of circumstances as something, a project kind of straddles one of these United States Census Bureau definitions?
So I'm going to pass the microphone over to Lloyd. I see Lloyd looks like he might have a response. So Mr. Spivak, could I turn that to you?
Yes, Commissioner. I did just do a little bit of research on exactly that question. What I found is that the Census Bureau does not actually embody these definitions and regulations. They do it in mostly in a series of advisory documents, but the formal discussion of their definitions are an entry in the Federal Register, at least for the 2010 census. That seems to be the most recent definitive document, and we could reference that provision.
That's what you heard earlier from Commissioner Herman saying where did you find these definitions? So if it's in the Federal Register, there should be a citation.
There is a citation for it, and I do have that citation, and we could conceivably incorporate that.
So we're pretty certain that some hard lines here. So, again, would like La Plata be considered urban area, and if so, something were,
From what I saw, the definitions, what they actually do is define it by population density. So, and they also say they break it down essentially by census tract or census block, and then define that by population density. So they do have some very hard definitions there. In terms of how it's done. It's just that it's like I said, it's in the Federal Register rather than specifically in Census Bureau regulations.
Okay, maybe you could help direct me to those after this offline, and because again, you heard my first concern. I think we ought to expand this, but the next concern I would have after that is clearly define what constitutes an urban and densely populated, because in Maryland that could some of these areas can be very close to each other. And, that seems to be where some of the plans we're talking about. situated in areas that may be defined as on the line between rural, but very close to a densely populated area. So anyway, thank you.
Thank you. Any additional matters with respect to item chapter 1? If not, we'll proceed to an overview of chapter 2.
Okay. Thank you, Mr. Chairman. I'm going to now bring up chapter 2. So chapter 2 mainly focuses on enhancing notice requirements, and it does make a couple cleanup changes to the distribution of a CPCN application to the various state agencies. So unless the commissioners have questions about the distribution revisions, copy numbers, things like that, I'm happy to go into that. But unless you have questions about that specifically, I can go right to the notice additions. I'll just pause for any questions about the distribution edits.
1 second.
Yeah, I mean, it's look. Is the OPC requirement about how to access EJ screens? Is that it's in subchapter 2? Is that in?
It is.
What we're talking about right now.
It is, but that I will cover in a moment as part of the notifications. Right. What I'm asking right now is if commissioners, if you have questions about the distribution, the revisions that affect the distribution of the CPCN application.
Right, Mr. Chen, you're only referring to regulation number 2, the list of recipients.
2B, correct.
Right. Okay.
I'm sorry, you said 202?
Yeah, regulation number 2, which is on the screen.
Oh, good. Okay, on the screen. Okay, thank you.
02 and B specifically, because B provides who the applicant needs to distribute the application to, as far as the state agencies and governing bodies.
I just had a drafting comment regarding number 6. Yes, that's it right there. This particular one requires the notification to go there, but then in the parenthetical at the back it says notice only. So I noticed throughout all of these we have parenthetical in the end that gives additional direction about what type of notice is supposed to be sent. So I would just check to make sure that that's the appropriate way to draft this type of regulation, because they all kind of suggest different things at the end. And so I think there's a stylistic way of drafting COMAR. I'm not entirely sure that that's the appropriate way to do it. But
if the team will look into that, so it's conforming with COMAR standards.
Thank you. That was it for me, Mr. Chairman.
I also have a question on 7B. It may have changed, but I seem to remember that directorate being the Water Resources Administration instead of the Water and Science Administration. Someone check on that, please.
Very good point, Commissioner. This was the information that was provided to me directly from MDE, because I did ask them for their, sort of a green light approval, whether or not we can reduce the copy numbers from 4 to 2 and who should receive them. And this is what I got back.
Yeah, no problem. It may very well have changed. You just, so someone in that portion of MDE should be notified. I just seem to recall, and it could have changed, but not too long ago. I think it was the Water Resources Administration.
We can double check and make sure it's the correct title, Commissioner.
Thank you.
Okay, why don't we move along to section D of that regulation?
Okay. Moving to section D, and in this Section D will require then the mailer. This is the mailer provision that that an applicant would then now be required to send by first class mail notice of its application filing to all residents and business addresses within a 1 mile radius of the proposed facility and within a 3 mile radius of the rural area. And this kind of touches back, kind of calls back to the numbers that we use in the definition of an affected area again. So if anything, it's really just not stated here, but what's implied is sort of like the cost consideration, balancing that for the developer against the objective of providing notice to those who would likely be most sensitive and most affected within that particular 1 or 3 mile radius there. The details of the requirements of the notice are what they are. So if anyone has any questions about that, I can address that. Section E, subsection E now requires making a copy of the application available in a public library branch. Now, in some CPCN cases, the applicant has done this in the past. Now we make this a requirement. This regulation would make it a requirement for any CPCN for a qualified fossil fuel generating station. And then subsection F now would require the postage of signage here's a distinction here, for all fossil fuel generating stations that are subject to a CPCN requirement. So up until now, the notice requirements, the pre-application requirement really only apply to the qualifying generating stations. These are the large ones, large fossil fuel stations that are 70 megawatts or larger. F, the signage requirement would apply to all fossil fuel generating stations, including those for which a waiver has been denied. And this signage requirement, I think there's been a proposal that the applicant, in addition to posting a picture, but also disclose the location of the signage. I did not clarify it in these regulations, but that is a reasonable addition to F.
Thank you, Mr. Chen. I recognize we have the sole comment from OPC regarding item number D5 or proposed D5. If you could scroll up, Mr. Chen. I would find it reasonable, and I would pose the following revision if Mr. Chen, you could add it to a number 5 there. That it would read, number 5 would read information on how to access the EJ screen. That would go right under number 4 there. We'll hear from OPC in a minute, but other commissioners.
Mr. Chairman, I'm sorry to interrupt. I do want to say that OPC did provide me with proposed language that would meet that is consistent with what you just suggested.
Oh, what did their language say?
Their language, and it might be easier if I just pull it up in the document that's a little smaller to read. I'm sorry.
Well, OPC did not propose anything in its comments, that's for sure.
It did not. It did not. But here.
Well, we don't need to see it. Why don't you just read it to us?
Okay. It says the company shall furnish in its notice of public hearing a statement that the EJ screen report has been completed. Maintain a copy of the EJ screen report on the company website, and include all relevant information for the public access for the EJ screen.
Oh my God, that's sorry.
Mr. Chairman, I have to say that makes me a little uncomfortable because they didn't give that to any of the parties.
No, they didn't, and that doesn't really fit very well as a number 5. Actually, why don't we hear, if the commissioners indulge, from OPC at this point? We'll bring him into the conversation, but I prefer my proposal on information on how to access the EJ screen period. Mr. O'Laughlin.
Morning, Commissioners. I apologize for the screaming child in the background. Sesame Street ended a while ago, and so we're at where we're at right now.
Can you pull down the screen so I could see Mr. O'Loughlin?
Yes.
Thank you. There you are. Good morning.
Morning again. Yes, OPC's main concern was just ensuring that the public had a method to access the EJ screen report, given that the company will go through the efforts to create such a report. We just wanted to make sure that the public had an opportunity to access it, given that it would already be done by the time of filing the application. It seemed to me a natural conclusion that they could have it somewhere on their website, and allow the public to know that it's there. Mostly, we just want to make sure that the communities are getting this information, because nowhere in there did I see a requirement that that be done. So otherwise, without some sort of language requiring that,
I think point. I know it's difficult to work at home with children in the background, but it sounds like it's difficult. Do you have any objection to my much more slimmed down requirement that information on how to access the EJ screen be required?
as long as there's a method for access, I think OPC would be satisfied.
All right, thank you, Mr. O'Loughlin. Turn back to my colleagues, either on this point or on other points they may have with respect to this regulation.
Mr. Chairman, yeah, I support the language for to satisfy OPC. I also want to just bring up again the Howard University Patuxent Riverkeeper requirement in, I believe it's an F, about having some kind of proportionality of the number of signs based on population. That seemed also reasonable. Right now, we just very vaguely say a minimum of one sign, but you could have some areas where, I mean, if they wanted to put a project right in, middle of where I am, you could have people who don't shop up at Rivertown and, in Fort Washington, but, do in the National Harbor area or other places. So I think, a requirement that be considered, the number of people, and also just the geography of the area. You may have a river that runs through the 1 mile radius. So anyway, it just seemed like a reasonable requirement to have some proportionality to population.
Thank you, Commissioner. For reasons similar on the other topic that the Patuxent Riverkeeper brought up, the F1 does say at a minimum one sign. I know that Patuxent and Howard did say one sign per 10 households. That'd be lots of signs on the street, depending on how populated the subdivision is. For that reason, I'm comfortable with staff's proposal of one large sign at the site of the proposed facility.
Yeah, I don't think the number of signs they require, but maybe it's one side per 1,000 or something of that nature, particularly for the urban areas. Again, to take into account where the populations may reside and any kind of the geography.
It would have been nice to hear directly from the concerns of the Patuxent Riverkeeper, but their comments to me they had a particular ratio of 1 to 10, and this language doesn't bar the developer. And the developer, I think, if they were smart and wanted to head off a lot of public criticism, they would put more than just one sign outside of the facility. So that language gives me some comfort that there will likely be more than one sign. Other commissioners on this point?
Yeah, I concur with you, Mr. Chairman, on both points. With regard to the suggested language for the EV screen, I'm very uncomfortable with an unviewed one reading of sounded like some very complicated language submitted by OPC to Mr. Chen that I haven't had a chance to parse or view. So I'd be very uncomfortable with that adoption. Your language is more simplistic, and if it is adequate to make sure that there's access to the EV screen, I'm okay with that. I can support that. And additionally, I agree with your kind of assertion that there's no basis presented to us in the record, other than a suggestion of one sign per 10 households. To me, that's somewhat overkill potentially, and not having a basis for additional. The minimum wording is enough to satisfy me that there's adequate signage notice out there.
For the issue of the signage, I think one sign is fine. I guess the only concern that I'd have is that some local governments have their own code regarding the types of outreach and marketing signage that different parties can place on property in their region. It applies to everything from elections to solicitation and marketing. So I wouldn't want to adopt a regulation that runs afoul of a code that we haven't looked at or know anything about. I suspect that one sign every 10 houses would probably run afoul of more codes than others. So I think one should be a safe number, but we may want to encourage the applicant to make sure they abide by any local code as necessary for posting of signs, because it's there may be some locations where they are not able to do so, even though it might be the appropriate place to do so. With regard to the proposal to access the EJ screen reports, I guess I had a question about that for Mr. Chen. If I were to, Mr. Chen, if I were to access an EGS report, say 3 months ago or 2 months ago, and then I access the same, or request the same report today on the EPA's website, would I get the exact same report, or is the report going to look different as a result of new data or new information that might have been provided or updated?
Here we go. Unmuted. It's a good question, Commissioner. I think it's a little hard for me to answer that because I'm not too familiar with the real guts and the inner workings of the EJ screen tool and sort of like the behind the curtain. How does it all work? I do believe that a lot of the information as far as demographic information. Now the environmental information may go more to your point as to whether or not how often that gets updated by EPA. But the demographic information likely won't change that much because that's pulled from census data. And I believe currently, if you were to go today and run an EJ screen report, that would be utilizing largely 2010 census data, if I'm not mistaken. So the environmental indices, there are 12 of them. They pull from both environmental data and demographics. So there could be some changes, although I am not 100% certain on that.
Okay, well, in that case, then, Mr. Chairman, I do support your more streamlined language, but I would propose a friendly amendment to simply say that the applicant is required to post the report that they are using or relying on. If, for example, the report changes over time, then consumers that access the information later might see something different from what the applicant's relying on.
That's a fair point. So it would be information on how to access the applicant's EJ screen report.
Right, whatever one they're relying on.
Yeah. It would make no sense if these reports are static in time from 1 month to the next or 1 year to the next. So obviously they do change over time. Thank you. That friendly amendment is good by me.
Thank you.
Mr. Chairman, I agree. I think one sign is, at least one sign is sufficient. And I would note, Commissioner Linton, that I believe it says subject to applicable local restrictions and regulations. So I think you're already covered.
Great.
So I don't think we need to make a change for that. I think that's already covered. So I'll concur with my colleagues on that.
Commissioners have additional questions on Chapter 2's regulations?
I'm good with Commissioner Linton's friendly regulation or recommendation.
Thank you, Commissioner.
Just for the record, I wasn't advocating for a strict 1 to 10. just for proportionality. I was kind of hoping we could at least accommodate part of the request, but I wasn't advocating for 1 and 10, 1 sign for 10.
Mr. Chairman, I did have one other recommendation that, and I may have to call on our executive secretary to help me with this one. For D 2 and 3, the information that's supposed to be provided to the residential and business addresses within the 1 mile radius language. This section requires that the letter include the pre-hearing conference date and the deadline for filing petitions to intervene. That information, I think that and could ask the executive secretary or even the chairman to correct me on this, but don't we typically have the deadline for filing petitions is determining at the pre-hearing conference? Or are we going to determine that at the same time as the pre-hearing conference date? Because it's all supposed to be incorporated in a letter to customers. And I don't have any concern about providing the information. I'm fine with that. I just wanted to make sure that in our regulation, we're not asking the applicant to provide information that we won't have yet, or they won't have yet.
Commissioner Lynn, I'm obviously not the executive secretary, and he can kick me under the virtual table anytime that he wants. But as far as the current notice requirements go, I do believe that in CPCNs, the applicant typically publishes notice of a pre-hearing conference, and this is the pre-hearing conference being the scheduling conference where they would set the relevant dates for the proceeding. So the notice of pre-hearing conference typically includes that deadline by which you would file a petition for intervention. And then at the pre-hearing conference, the scheduling conference, that's the time where either the commission or the public utility law judge will address the motion or the various motions and requests to intervene.
So you're not referring to the pre-hearing scheduling conference, this is a different.
So
that's my understanding, right?
This is different. D.
Okay.
Yeah, D is different.
Okay. All right. Thank you. That's all I had, Mr. Chairman.
Thank you, Commissioner. At this point, if any parties, I know we addressed OPC's sole concern. Are there any additional comments with respect to these regulations, these proposed regulations? Hearing none, Mr. Chen will turn to Chapter 3.
All right, Mr. Chairman. Chapter 3. Quickly pull that up. Okay. Please excuse the edit bar to the right. That was inadvertently included. Doesn't really do much or say much. But this O3, Chapter 3 addresses only generating stations. And what it does is then it spells out with a little bit more detail. I'll get to the bottom here. Now incorporates, in reference back, now it incorporates the EJ screen reporting requirement and also the statement of public engagement. That will be 0.04. I'm sorry, this 0.3 should be a 0.03. And 0.04 refers to the statement of public engagement in participation. So notably here, what the regulation will require to do is, as I mentioned earlier in this meeting, in this hearing, the applicant not only as a pre-filing requirement would need to run the EJ screen report, but then as part of its actual application, it would need to include a copy of the standard report and also the ACS report, which goes into describes in more detail, sort of like the environmental criteria. So based on these two reports, this again is a predetermination tool that would equip the decision maker, kind of set the stage for the decision maker to identify potentially sensitive areas, and then from there, hopefully would generate some discussion, and the decision maker would then proceed how he or she sees fit. And then 04 is the statement of public engagement and participation.
Thank you, Mr. Chen. Do commissioners have questions on items 3 or 4?
Well, since I'm batting 1,000 for raising issues of Howard University and Riverkeeper, they did make a suggestion, which again I found reasonable in the subchapter 4, to also include some of the input of participants. I think, namely, they were interested in including the support or opposition in that certification. So anyway, I would just add that. Seems to be kind of consistent with a description of any terms, incentives, or resolutions reached between the applicant and the affected communities, or the sign-in sheet. So,
if I could respond, I did read over that, and I will say that part of that request initially to me sounded potentially overlapping with the public comment process that the commission would follow after the CPCN application has been filed. If the well, let me stay on that subject. There is an advantage, but then also disadvantage to including letters of support and letters of opposition along with the application, because then by attachment they become entered as part of the application and presumably entered into part of the evidentiary record. But unlike discovery mechanisms and data requests, a party that then has a question or wants to test that particular author of the letter could raise some issues, because then a party to the proceeding may want to cross-examine, for example, someone who's written a letter in support or written a letter of authorization, and some of the challenge there would be because the applicant does not have control or jurisdiction over a particular letter writer. That's a completely independent third party. They would have to then subpoena that individual, the author of that letter, to participate in the proceeding. So that is one consideration. Another is if you include letters of opposition, someone else may view that and see that and say, oh, well, my position's already spoken for, I don't need to participate now. So maybe it's an extreme possibility, but it is nonetheless a possibility that there could be an effect of chilling participation by folks who otherwise would try to intervene.
Thank you, Mr. Chen. I was looking at that, and I was thinking, why would an applicant why would they file letters of opposition with their application for the CPCN? But I did think about the potential for confusion, because we'll have our own public comment date where parties could come in, and they may have thought, oh, we've already had the public comment. The Riverkeepers it's a recommendation that allows for the applicants to file these letters. They could still file the letters. So I don't see really any utility with respect to Howard and Patuxent Riverkeepers' proposal, and therefore I do not support it.
I have a separate question on the provisions that were up.
Commissioner O'Donnell.
Mr. Could you put the document back up?
Do you see it, Commissioner?
I just see it now. So 04C says a copy of any meeting attendee sign-in sheet. And what immediately came to mind was what is on a sign-in sheet? How much is personal identifying information? Is it address? Is it phone number? Is it email address? I know when you sign in for a meeting of a committee in Annapolis that may be doing public hearings, you even have to indicate your position in favor with amendments, and opposition. So what, is there any bounds on kind of publishing meeting attendee sign-in sheets, protecting the attendees' interests or information?
Well, I think my first response, my gut response would be probably no different than the sign-in sheets that we have for public comment meetings, which then go into the administrative record. You know, if an attendee doesn't want to sign in, you know, there's no mandatory requirement that they sign in. And I think we offer this particular provision to help address community concerns that maybe, you know, folks that attend these meetings are not necessarily part of the affected community. So, I mean, that's the benefit of having the sign-in sheet, so that, you know, folks who are interested can know, well, who's attending these meetings? Are they really part of the affected community? Are they, you know, are they really representative of, you know, the community input in the community view? That's part of the feedback that we were trying to incorporate and learn from the whole Man or Woman experience. I can't get into too many of those details, but I will say this. You know, BTB Coalition, in their comments, they offer some substantial modification and revisions to Attachment C specifically. And my read of that is really to really try to get at identifying the key stakeholders and the key organizations and the key members of the quote unquote, you know, affected community. So, you know, I think I'd be interested to hearing from Ms. Gray and Mr. Weaver, you know, their views on the benefits of having a sign-in sheet. But to your question, as far as provisions, I mean, we protections. You know, I don't see there isn't a redaction requirement right now.
Mr. Chen, Commissioner O'Donnell, can I jump in? Is there any requirement? Because quite honestly, if I was just going to community meeting and signing in, I'm not aware that my information is now going to be submitted as a part of an application before a government body. I wouldn't feel comfortable with that. Is this copy of the sign-in sheet, is it a requirement under any of these EPA regs? Or can we just possibly remove this regulation?
I don't believe it's a requirement, but what I would like, if I could get the commission's indulgence, is to take a quick look.
Okay. Well,
what's controlling for the purposes of this rulemaking and these proposed regulations is the IRA agreement. And I don't believe that the IRA agreement specifically calls out for a sign-in sheet. However, if I could.
Why don't you look, Commissioner O'Donnell, thank you for allowing me to interrupt.
And before we hear from other parties on this, I just want to be clear. I believe there is some utility maybe in gathering this information. My concern is protections for the attendees from that information being used to lobby or pressure or coerce or otherwise engage by other parties somewhere down the line. I mean, it could be used for other purposes that were not intended, certainly here, in the utility of making sure that we know who was attending, we have a record of their attendance. So I'm coming at it from that perspective. I understand the utility of sign-in sheets generally for public meetings. However, this just seems like this is being published.
Well, so Commissioner, I do recall in our initial discussions with the federal agencies whether or not we needed to go as far as require that attendees identify themselves, their address, things like that. And I think that where we settled were, as far as envisioning, was a sign-in sheet where folks who are comfortable then would just put their names and their organization.
But this doesn't say that.
Right. It's a little vague. You're right. It just says attendee sign in.
So maybe if we look into it, maybe we'll end up not having it there. But I just wanted to clarify where I was coming from on this, protecting the interest of the community members themselves.
So I think I would agree with Commissioner O'Donnell's concerns. I don't know that this would be a valuable document. You haven't been to a number of these before. You have all kinds of issues with sign-in sheets. Some people don't put their full name or correct information. Some of them are not even legible. It's hard to read them. In other instances, people don't even provide a comment. They simply say, never mind. And the sheet may not be maintained well enough to recognize or to track who actually says anything and who doesn't. So it can reflect one piece of information when it may not necessarily be accurate information for what happened at the hearing. So I think we need to understand what we'd like to use it for before we decide to incorporate it into a regulation.
Mr. Chairman, the IRA does not require identification of who attends the community meetings. All it says is that, the applicant would be required to identify actual community members. This was in chapter 1, but that doesn't mean who attended the actual,
No, I wouldn't expect that those two provisions required an accounting of who attends the meetings. And as just articulated by Commissioner Linton, these sign-in sheets could be a mess. People could go in, they could write John Doe. I've done that before if I don't want to be on the record, but I feel inclined or pressured to sign in. I would support just removing this requirement altogether. I don't know how my colleagues feel on that.
Could I just have a quick question of Mr. Chen? Now, it's my understanding this is a non-consensus section, but didn't the advocates, I would call Howard University, Patuxent River, other advocates, they were in favor of including this section. Is that correct?
Well, can I just clarify the consensus, non-consensus? It depends on how you look at it. If it's, if the regulations relate to the regulations were intend to satisfy the IRA obligation, and in that sense, there is consensus between what the commission agreed to submit to rulemaking and what PHMSA asked us to submit to rulemaking, that they mirror. So this is consistent with PHMSA. So in that sense, there is consensus. But if you're talking about the comments, if you're talking about outside parties like Patuxent River and Howard University, and you're right, then there's of course their view that whether or not this is sufficient for achieving whatever goal and position and satisfying their position.
Okay. Well, Mr. Chen, like you, if Mr. Weaver and Ms. Gray care to speak up on this, what I've heard from again, I would call them the advocates of this pre-application process, is that they want to be heard. They want to be heard at the very front end, and they want to be a part of the record. And so that's where I'm going into this, thinking that they wanted to have this as complete of a pre-application record as possible, and they wanted their voices heard. And that's why I believe they wanted to also, again, include some of the positions expressed. I mean, I agree with the concern you raised that there could be confusion, and you're right. We need to be careful that people don't assume that because they participated in this pre-application that somehow this is the process, the end of the process. But this is something that the advocates had wanted. They want to be heard early, and they want to be on the record. And so, again, having some sense of who's attending these meetings, what was discussed, and as is in D, anything that might have been decided at these meetings as far as incentives, concessions, or anything else. Again, it's for the completeness of this pre-application process. I believe it's my understanding what is intended by this, enhanced process. So again, if Mr. Weaver or Ms. Gray want to speak up on that, if I'm understanding this incorrectly, I would welcome their input. So.
Am I on now?
You're on.
Okay. I agree with you, Commissioner Richard. You're right. You're right on point. Living this in Brandywine, we had to fight through lobbyists who brought in large contingents of out-of-state power plant workers who completely filled the room, and the Brandywine citizenry couldn't get in. They're outside complaining. We're watching Greyhound-sized buses outside with these people all dressed in T-shirts and things, which is very intimidating. A sign-in sheet. If we go and listening to as a Chairman Stenick, I look at your sign also, but the sign-in sheet makes D possible. C makes D possible. The next line down. It also, if you made any changes, then say interested parties who would like to go further with this sign that particular sheet. But that should go in that the builder applicant is actually went through the process. Actually, this sort of verifies that they've actually reached, or does verify that they've actually reached community members. And I think that's the most important thing here. We felt that we were not a part of the process at all in this. And we, I hope that this is something that if Kamita, you want to continue, go ahead, and I'm going to sign out here.
I mean, Mr. Weaver, the question was, do we need a sign-in sheet? Is your position, yes, we do?
Yes, we do. But instead of maybe saying, let it just say, okay, who attended, it could be who has, parties of interest. It could change that to change the language in it to parties of interest, where they would be willing to go on to the next level and have negotiations with the applicant beforehand to possibly work on mitigation for their area, especially like a Brandywine that has 15 polluting sources of negativity there for them.
And how do you respond to the concern of Commissioner O'Donnell that there may be some privacy violations? If I show up, I'm just there to listen. I don't necessarily want to get involved and have my name as a part of the record.
Right. That's where person of interest comes in. If you change that to mandatory sign-in to person of interest, then those who are interested can sign in, and those who just want to be a part and participate in the future, or don't want to participate in the future, just want to find out what's going on, then they don't have to sign in. But I think parties of interest like myself, I want to sign in. I want to be a part. Talk to me, applicant. Talk to me, whoever. Parties that are in, yeah, I want to be a part of this.
Thank you, Mr. Weaver.
Mr. Weaver, can I ask you a question?
Sure.
Mr. O'Donnell, if you wanted to be a party, but they wanted your date of birth, because we're not controlling the form, I guess. So there could be some extreme situations where they're getting personal identifying information that they really have no good use for. There's no reason to ask you your date of birth, or for that matter, maybe your telephone number and publish it so that someone else can pressure you against your position. Would that concern you at all, or should we put some reasonable bounds to protect your?
We can just keep some reasonable boundaries: name, address, phone number, email address, and or email address. People don't usually like to be contacted. I myself, if we haven't established a relationship, then we'll talk through email. email serves a purpose. You know, I might not want to give you my phone number, my address. I'll give you that. But if we put something there where those things aren't there, we're pushing too much, giving too much information, I would be fine with that.
Yeah, and as you know, some of these things that are very controversial, you got very emotional parties on both sides of an issue. I certainly viewed it here in my community for the CPCN process regarding Cove Point and how that may play out with this kind of information between the various parties and pressuring each other, et cetera, et cetera. So I'm really just, so I think there is utility, as I said, to gathering information for who wants to be a party and who wants to go forward, who wants to be heard. There is utility there, but we also have to do it with some, I believe, with some reasonable bounds to protect you from intrusive gathering of certain personal identifying information and then publishing it.
Yeah, okay, but I still say C makes D possible here. It blows the whole document up if you don't have some way to communicate with the community on a continuous basis.
To be clear, I'm agreeing with you that there's some utility there, but that it has to have reasonable bounds, maybe to protect you from being required to disclose information that you may want.
Yeah, just put limitations on that. I think we're fine. But on again, Chairman Stanik's position, and just let's not make it mandatory, but at least if you're a person of interest, if you want to be a party of interest, we have that with our planning board. Those who want to be a party of interest, we can sign these things and we can be notified. And I think,
I'm fine with that.
But I know this isn't a and this can go in to show proof that this applicant reached people. This actually, unless we do videos or something with it also, this is something this has occurred. This meeting has occurred.
Mr. Chairman, I know Ms. Gray wants to get in on this. Can I just ask Mr. Weaver, what about the request by Riverkeeper, Patuxent Riverkeeper and Howard University about including letters of support and opposition? Do you have a specific comment or stand on that recommendation?
No, I'm against that, and the reason why I'm against that again is the same thing that the chairman and I think Commissioner O'Donnell brought up. Now you're talking, they're trying to bring something in, and this is to get you to. This is to get you into the game. This is public engagement that we're doing here with this form. This gets us in the game and says, hey, you're being notified. The state is notifying and the applicant is notifying the heck out of you here. Participate. And if you choose not to, then that's it. But that gets you into the game into the flow of the process. It gets us involved. And so that's also an added benefit of being included in the sign-in sheet. The sign-in sheet, hey, the applicant may want to continuously keep us abreast of things. You guys may. We all look at the cost of mailing things out. We look at the cost of actually getting these things out. But for us to get our word out, to get the word, the pre-application should just be for it's for the applicant to show that they've reached out and the public has without a doubt has been notified.
Okay, thank you. Well, that informs my position on that. Then so you'd prefer not to have those letters included in the record. So thank you.
No, yeah.
Thank you for clarifying that for me.
I would propose, and Mr. Weaver,
I think Ms. Gray wants to say something here.
On having those letters of support or not in support of, I would not agree with it being in this process because the PSC has the public comment process. The other part with the sign-in sheets are governed by the sunshine laws of public meetings. So if you have an open meeting, there's only certain things that you can do on a sign-in sheet. So you can't, you're not allowed by law to collect demographics or information that doesn't pertain to just signing into a sheet. So if I sign into a sheet and it's a public meeting, which means it's open to anybody, then anything that goes on there, even recordings, is public. So if I voluntarily sign a sign-in sheet, that information is ordinarily public. We know not to ask race or demographic other information because that's not allowed by law. So I would hear, it doesn't bother me whether there's a sign-in sheet or not here. Our issue was the sign-in sheet with the PSC public comment process. But it wouldn't hurt if it was here to show who attended this public hearing and knowing the radius of the people involved, which is where Brandywine got into trouble, because the people involved were outside of that 3-mile radius. So this process went on with the Patuxent Riverkeeper, Clean Air, and other participants that were 4 to 10 miles outside of the process. So when you're talking about affected communities, there is definitions, and that falls under NEPA laws. So it is very well defined of who an affected community is versus having an adverse effect. So adverse impacts would be your pollution, your other things, your noise. So that depends on the radius of how far. So you're more affected closer, you may be less affected out, you may not. But those are called adverse impacts, not affected. The affected is the fence line. And then I do want to say this, Maryland law, which is how this came about, only states that in any process, you only have to notify the abutting properties. So that's why this was of concern, and we came up with the 1 to 3 mile radius to supersede projects or developer in this sense of being notified.
Thank you, Ms. Gray, for those comments. Let me just add, it's 12:30 now. If this hearing goes beyond 1:30 today, we're going to call a 2.5-hour recess and pick up later this afternoon, but we have another hour that will keep moving. With respect to this, the sign-in sheet that we've been discussing for the past 20 minutes, I would propose to my colleagues, if they're comfortable, that the regulation be revised to state a copy of any meeting sign-in sheet indicating persons of interest.
So you're saying there would be no names, or it would just read person of interest, like a tally?
No. The folks who would want to sign up, as Mr. Weaver explained, would self-identify as persons of interest, and they'd sign the sheet.
Okay.
And Mr. Chairman, I had thought that we might add in voluntary before sign-in sheet, so that nobody feels that they have to, and that would have to, and then the applicant would have to demonstrate that it was in fact a voluntary sign-in.
I could amend that to say a copy of any meeting sign-in sheet voluntarily indicating persons of interest.
Fine. Yeah, I mean, I think that way it's, and if there was a question that somebody said, well, I felt like I had to sign in, then, the applicant would have to demonstrate that it was a voluntary sign-in.
I'd be good with that.
That works for me.
Thank you. Unanimous agreement. So Mr. Chen, it would read, Regulation 4C would read a copy of any meeting sign-in sheet voluntarily indicating persons of interest, semicolon, end stop. Thank you, Mr. Weaver. Do we have additional comments or proposals with respect to Chapter 3? Hearing none, that concludes this portion of today's rulemaking session with respect to the proposed regulations. I recognize in the BTB's late filed comments, they had some concerns with Attachment C. The Commission is not ruling on Attachment C. This is a staff template. It's a document for best practices, as we discussed earlier, but we recognize that you filed 2 comments. The first one redacted on Monday, and the second one was more public on Tuesday. So Mr. Weaver or Ms. Gray, give you an opportunity to explain any concerns that you have.
Yes, good afternoon. Thank you. So I just want to clarify a little bit. The comments were due on Saturday the 16th, so it was my understanding that we had until Monday, close of business, to file the comments. I inadvertently filed them in the public comment section, which is not where I was supposed to file them. So that's why I had to refile them on Tuesday. And then there were parts that they felt shouldn't be redacted because that caused other issues. So then I refiled the unredacted portion of it.
Okay, thank you. We have them before us now, so.
Okay, thank you so much. I'm concerned as a community affected person and as a resident of Brandywine. So having clarification on who is participating. So Brandywine is the zip code of 20613, which brought in the problem of it being Brandywine, the census designated place, which is what that stands for. The census designated places are also included in the EJ screen so that we know that we're talking to Brandywine residents, not 20613. If you look at 20613, it is 32% African American. If you look at Brandywine, which is where this is located, it is 72% African American. So when 20613 would be a Costco, Baden, Croom, Akakeek areas, which are not as the affected residents. They have adverse impacts in their community, but they're not the affected. When you say affected, these are the most reasonably impacted, legally congeniable residents that should have something. So the best way sometimes I describe it is like your dishwasher. If it overflows, it affects the kitchen and those areas. It doesn't go into the bedrooms. Not that you may not hear the noise or the other things from the dishwasher, but the dishwasher immediately affects the kitchen. The reason I want to hone down on the application in specifically identifying who's at those meetings. Now, we do work with Sierra Club, we work with other organizations, but they do not take on the issues of the locally based community residents. They are our technical support. So it is key in not to be discriminatory in who exactly you are talking to, which is the reason that I wanted this part of the application expanded. And then also, what legislative bodies are you talking to? Well, with us, the local, which is county council, or if they're delegation, or if they're state level people involved, or parking planning, which is involved. So those were the main issues for this, is knowing exactly who, and the experiences with Brandywine in not knowing for 2 years after the process. So 2015, it started in 2013. We weren't aware until the fall of 2015 that this project was even going on. The other thing is we're not in the Patuxent River area, we're in the Potomac. So we had to then get the Potomac people involved because it was mainly a focus on the Patuxent when it's the Potomac that this project sits in. So it's imperative that we know if we're talking to a church. They don't represent members. Our group, the BTB, represents residents, and the membership are residents. We belong to a bigger nonprofit that represents a broader interest of the issues, not specifically the issues of community. You have to make sure you're educating community. You may have to make sure that those residents understand and are educated on the process. It's not for me to even speak for the residents. It's for me to come to a consensus with the residents and to put forth what it is, the questions they have, in educating them. I do have my personal opinions, but those are specific in that we know whether it's a bigger nonprofit, national nonprofits, locally based, and all those there's a lot of terminology, but all those are well defined and even without and throughout the NEPA process of the guidelines of Title VI law. Understanding that environmental justice is not a law, which is the reasoning you have so many different definitions of what one should do. The other issue is when we looked at the 1 to 3 mile radius, 1 mile in an urban area such as Baltimore, if you did a 3 mile radius, you would have 10,000 people. If you do the 3 miles in Brandywine, you may have 7, maybe 7,000. Brandywine is 6,000. So the urban areas, the further you go out, the more you're going to have people that are involved that may have an adverse impact, not the fence line hosting community, which is who you want to make sure that you're engaging with from the beginning. And I don't know if you want to add anything, Al.
Seconding what you're saying, I again, yeah, the 1 to 3 mile radius issue, it's a density issue also as well, and you pretty much laid that out here. When we were getting involved, and well, Kamita was involved first, and I was brought in, and I looked at the groups that were helping out, and we actually had a situation where we had a representative from the Sierra Club who was with us and helping us from the National Sierra Club, who told us we're not allowed to speak on public on national natural gas power plants, and we were shocked. And so we were then we started to do our research, and we began to learn that, hey, wait a minute, these groups aren't really representing us, they're representing their interest. The community is the community, and if the community doesn't fight, they're going to get rolled on. So, you know, you roll your sleeves up, you get in the game, and you really take this thing on, and you work with try to work with the business if there's an opportunity there. We felt on this particular project that there was a slick move. The reason why it was 2015 before the community found out, because just a mile away, there was another power plant that was coming through first that sort of intertwined, and people were confused to what they were even talking about. Then we hear this new power plant, and we're like, whoa, what is going on? It's too late at that point. And then again, a community-oriented group stepped in and filed a judicial review featuring Title VI, and in that judicial review, and it just, none of it made sense. It was a mismatch of just people just trying to pile in on us and not paying attention to Brandywine. Brandywine's needs, what we want. We would have loved to have the opportunity to have spoken with Panda or anyone else involved. We would have loved that as a community. We would have embraced that. We're not here to hinder business, but if it's wrong, it's wrong. I mean, that particular area we're not necessarily in agreement with. But yes.
Your position today is that these proposed regulations would go a long ways to addressing all those unfortunate concerns that the Brandywine residents faced a few years back. Is that correct?
Chairman, you have a way of making things short and concise. Yes.
Thank you, Mr. Weaver. Well, we received your comments that were cabined off to attachment letter C, and that it, like I said, that's the best practices template that the staff has developed. I will direct staff to consider them as they work on that, finalize that. It'll be a posted document. It's also going to be a living document where it may have to change from month to month, year to year, project to project, and staff will be mindful of that. That's not a document that the commissioners vote on or micromanage, but I'd like to, since you took the time to propose some changes and air your concerns today, Ms. Gray as well, thank you. If the commissioners have any questions of the representatives from B2B.
No questions, but I appreciate your participating today. It was very helpful, at least to me, and helps inform my opinions. So thank you.
I have no further questions, Mr. Chairman. Do appreciate the input. And I would like to say a few words before we wrap up here after other commissioners have a chance to ask questions if they have any.
No questions, Mr. Chairman, but I echo my colleagues' comments, and I appreciate the participation and the comments.
Thank you, Mr. Chairman. I have no questions.
Thank you. Commissioner O'Donnell.
Thank you, Mr. Chairman. So from the time I was born, or a couple of days thereafter in 1961 until 1974, I lived less than a tenth of a mile from the fence line of a coal burning fossil plant that was well before any realization of the environmental impact on a local community. And this was a working class, poor community, to be honest, of such a facility in the midst of our neighborhood. And we just dealt with it growing up. But I have to say, it wasn't right in retrospect. When I look back on some of the things I experienced as a member of that community, it just was not a healthy situation. And I'm very pleased about these regulations moving this ball forward so that communities of interest and specifically our minority communities can avail themselves of processes which have them heard adequately. And I think it's very important. And I think we're doing this in a thoughtful way, in a thoughtful manner. And so someone who's experienced living within 1/10 of a mile for many years of a emitting behemoth belching stuff out, I appreciate these efforts and the input and the work that has gone into them, and the IRA and the whole 9 yards. So I had to say that just to say this is important to me, as I know it is to the rest of the commission.
Thank you, Commissioner O'Donnell. True words have not been spoken. We do appreciate the input of the public, and it's a testament to Ms. Gray and Mr. Weaver as the only two members of the public here today. It's an important issue. I hope that you feel that you've been heard today. And at this point, we're going to proceed with a vote on the proposed regulations with respect to RM69. Commissioner Richard, I see your mic is on. Did you have something to say before I call a motion?
Oh, not necessarily. I guess I just never turned it off. But yeah, I would echo a lot of what Commissioner O'Donnell said today. I think this is important that we move forward today. I mean, I obviously, as I spoke up during the discussions, I would have liked to have gone a little further in some places, but I think these are important. This is an important rulemaking as far as allowing the public to be heard and to make sure that their notifications do go out, and that there's this pre-application process so that these projects do engage and they do listen, and they this does hopefully have some bearing on final decisions. So yes, I strongly support what we're doing today.
Thank you, Commissioner. And I'll just note that this commission, the PSC, is thoroughly committed to the input of the public. A great example would be last night, where we had one of our chief judge take public comment regarding a proposed wind turbine facilities out in the western part of the state. The judge convened last night at 6 p.m. and the hearing went very late until almost 10 p.m. last night. And opposition had an opportunity to speak. And Mr. O'Laughlin, I think you caught it. I heard the kids. You. All right. We're getting static. I can't tell from where, but at this point, I'll make a motion on today's proposed regulations as amended. And that is that we move to publish the proposed regulations filed by the commission staff in this docket on April 7th, 2020, as amended today in the Maryland Register for notice and comment, subject to non-substantive changes necessary to conform to COMAR drafting requirements as follows. First, the revisions to the name of the subtitle of Title 20, Subtitle 79. Second, new regulations in Title 20, Subtitle 79, Chapter 1, Regulation 4, and Title 20, Subtitle 79, Chapter 3, Regulation 3. And third and finally, the revisions discussed today to existing regulations, number 1, number 2, number 4, number 6, and number 8 under Comark Title 20, Subtitle 79, Chapter 1, and with respect to regulation number 2 to Chapter 2 of Comark Title 20, Subtitle 79. The vote begins with Commissioner Richard.
I vote aye.
Commissioner O'Donnell.
Aye.
Commissioner Linton.
Aye.
And Commissioner Herman.
Aye.
I vote aye. The motion is approved, and the proposed regulations will be published in the Maryland Register as amended today. Thank you for your attendance and participation today. This rulemaking session is now adjourned.
Thank you, commissioners.
Thank you, commissioners.
Thank you, commissioners.